Okay, good afternoon, everyone, and thank you for joining us today. Today, our webinar, Hot Topics Employment Law Updates, is hosted by the Association of Legal Administrators, a premier professional association connecting leaders and managers within the legal industry. Special thank you to Cynthia Schuler and Monique Terrell from the DC ALA chapter for organizing the event today. Our presenter is Thomas L. McCauley. Tom is an equity partner from the law firm Carmeloni PC, a business and litigation firm serving the Mid-Atlantic. Tom has over 25 years of experience as a litigator, business advisor, and outside general counsel across a variety of industry groups. Tom is also Carmeloni's employment and labor law practice group leader, regularly representing clients in federal and state courts, as well as practicing before the EEOC and state/local EEO agencies. Before we get started, I would like to kindly ask all attendees to make sure their mics are muted and videos are turned off for the duration of this presentation being recorded today. Please type in your questions in the drop-down question box, and your questions will be addressed at the end of the presentation. A recording of this webinar will also be provided for registered attendees. Now I'll hand it over to Tom for today's presentation. Thank you.
Good afternoon, everyone. I wish I could say it was good to see everyone, but since I can't see you, I just want to thank you again for the opportunity to speak to the ALA and go over some of these new and challenging laws, regulations, and guidelines that I'm sure you all have been dealing with as long as I have since the pandemic started. As I always say to this group, I'm talking to the experts, so it's nice to be talking to people who are in the trenches and dealing with these issues because you all bring a different perspective as well. As Aaron said in the introduction, normally I like to take questions during the presentation. As you all know, this format makes it a little difficult to do that. But if you do want to type in questions while I'm speaking, feel free to do so. And if I'm able to focus on one or two or more, I will do that. Otherwise, we will take them at the end of the presentation. To begin, the purpose of the presentation is to make sure everyone is alerted to the rules, regulations, and laws that we're all dealing with right now. And what's interesting at this time for employment attorneys and for administrators, HR professionals, et cetera, we're not just dealing with state and local laws. We're dealing with guidelines, we're dealing with guidance, we're dealing with at sometimes executive orders, all addressing issues during the pandemic. And all of these laws and guidelines and guidance that come out, which seem to be happening almost on a daily basis from the Department of Labor or the CDC, are really being adopted by our 3 local jurisdictions as their framework for businesses to reopen. And today I will focus on law firms and office environments with this presentation. So why is it important to understand the interaction of all these laws, these guidelines, and the guidance? Is because we're expecting a wave of litigation with COVID claims. We've already seen it start somewhat for larger employers with Department of Labor and OSHA enforcement actions. We have not seen a lot of individual litigation yet. That I would describe as a wave, but it is picking up with people who are claiming they were either terminated or adverse job action due to something related to COVID. So employers at this time can't really rely on states enacting liability shields or the federal government. There's been a lot of talk about it. Some states have done it, others have not. But the bottom line is the best way for an employer to defend itself against potential future claims is to understand the federal, state laws and the federal guidance, as well as state and local guidance pertaining to COVID-19 in the virtual workplace, as well as we gear up to return to work. And understanding and complying with this mishmash of laws, regulations, and guidance will give you the best defense against any potential future claims. Guidance or compliance will also help you provide the safest environment for your employees to return to work. And one example, and we won't stay on these very long, of kind of the mismatch of laws that we feel in this region are the differing phases of reopening for the 3 local jurisdictions. DC right here on the screen now is in phase 2. That's a brief summary. You can also go to the DC Health website that has the specific multi-page statement of phase 2 guidelines for offices reopening. And what is important to note, DC, like Maryland and Virginia, has essentially adopted the Department of Labor guidelines for dealing with COVID in the workplace, as well as virtually, as well as the CDC guidelines. There are some unique characteristics that each state has adopted and not adopted. One of those for the District of Columbia is the 14-day quarantine for employees who travel to what they've designated as a hotspot, and that those employees who are returning before they can come back into the workplace must quarantine. How they're going to enforce that is a big question, if they can enforce it. But what I can speculate is that if there is an incident that's related to someone who did not quarantine and the employer knew and allowed them to come back into the workplace, that could be potentially a piece of evidence that would be used against the employer. Maryland is another interesting example of kind of the mismatch of guidelines. Maryland's in phase 3, except for Montgomery and Prince George's County and maybe some of the further outlying counties. So not only do you have to be aware of the federal laws and guidelines, it gets down to the states and county level as to what they're permitting. So wherever you have offices, it will be important that you know what those guidelines are and what they're saying about your reopening those offices in those areas. Again, most of the states have adopted the OSHA and CDC guidelines for virtual work and for reopening. There are some individual tweaks, and you should pay attention to those as you start the process of reopening or considering even moving all to virtual work. Now I'm going to turn to the federal statutes and guidelines that deal with COVID in the workplace. And the first one we're going to address is one that I'm sure you all have been dealing with since the statute was enacted, and that's the FFCRA. The FFCRA will remain in effect until December 31st, 2020. We could see that extended. That is something there's a lot of chatter about that. We have not seen it yet, but as Congress debates the current relief bills, I do expect to see some extension of that possibly. That statute, as you all know, provides certain leave for individuals who fall into 6 categories. And I won't spend a lot of time on this since you all probably already know it. You've been dealing with it. But the first 3 categories, those are paid out at 100% pay with a cap of $511 a day for a 2-week period. The next categories you have 4, at 5, and 6. Those are paid at 2/3 pay, capped at $200 a day. And then uniquely for category 5, caring for a child who can't go to school or their daycare, you can get an additional up to 10 weeks of leave at that 2/3 pay rate. So that gives individuals dealing with childcare issues up to 12 weeks of leave under the FFCRA. This next slide is a summary of it. Again, I'm sure you all are dealing with it. I will note one of the most recent updates from the Department of Labor is under the third bullet point that says not eligible for FFCRA leave if a parent elects not to send the child back to school or daycare if it's open. And what does that mean? As the schools start to reopen, they're cutting back on this benefit. And they're saying if a parent chooses to voluntarily keep the child at home when the school or daycare is open, the employer does not have, they are not qualified for FFCRA leave. They may take other leave if they have that available, but they're not necessarily qualified for FFCRA. As part of that, if the school is open in a hybrid model that we're seeing a lot, where there's leave for, say, or school's open for 2 days, but not open for 3 days when the child's at home, then you can prorate it if they're only partially open. The key here is whose decision is it? And if the parent decides to keep the child out, then there is not going to be a triggering event under the FFCRA. And here, these are just the general parameters. It applies to employers with fewer than 500 employees and employees who have been employed at least 30 days prior to the leave request can be eligible for the additional 10 weeks of leave to take care of a child whose school or daycare is closed. That 30 days does away with the FMLA's requirement for longer periods of service before you're eligible. So that's a brief summary of the FFCRA. What are the potential ramifications if an employer does not comply? Very similar to the FMLA. Also similar to the FMLA, if an employee returns from that leave, they have to be put back in their job or very similar, substantially similar position unless there's fewer than 25 employees. Employers can't discharge, discipline, or otherwise retaliate against the employee for taking such leave. If there is litigation, again, very similar to the FMLA, and it really adopts it, they're entitled to back pay, front pay, liquidated damages, attorney's fees, etc. As you know, that can get pricey if attorney's fees are involved and costs, also front pay and back pay. So giving the FFCRA leave should be a no-brainer, also because it's not costing you anything. The employer gets reimbursed through tax credits for all of that leave that is given. Now, something very important to remember during this process or during the pandemic, you have to stay aware of your state and local laws dealing with and maybe augmenting the FFCRA. And a number of jurisdictions have expanded that leave or provided for additional potential benefits. And one of those is DC. The District of Columbia Supplemental Emergency Amendment Act that amends the DC FMLA and also adopts the FFCRA as leave categories. What this statute says essentially is that the employees are entitled to receive full pay by utilizing their DC sick and safe leave pay if they are taking leave for a leave protected under the FFCRA or provided for. So at least 2 of those weeks, the 80 hours, would be at full pay, even though the employer would get credit for it under the FFCRA. So just be aware of that. If an employee takes that leave and they want to be paid fully, the employer utilizes their paid sick leave to make it a full payday rather than payment under the 2 caps that I explained earlier. We have not seen a lot of litigation about this. It is something that we could particularly if employers don't follow it. So be aware of it. If an employee wants to augment their capped leave under the FFCRA with their paid leave, they can do so under the district law. Even if you don't provide paid sick leave normally, you have to under the district law. Now, under the district's paid leave, you have to let them use it for FFCRA to augment. Under the federal statutes, you can augment the leave regardless with their current paid leave to get them up to full pay during that time period. That is this statute, the FFCRA, as well as the DC Supplemental Emergency Act, is probably the one everyone's most familiar with and how it's been impacted under COVID and the employees' rights. I will say that as we move forward, it is going to be important to understand, and this is our next section, the federal laws that apply to teleworking or virtual work, as well as the office environment and return to work. This slide gives you a checklist of all the statutes you should be thinking about as you're dealing with employee issues during COVID. And we'll go through these in detail during the next part of the presentation. But just as a brief summary and checklist, number one, OSHA. OSHA does apply to all workplaces. Employers are required to have safe workplaces under OSHA. And more importantly, OSHA has issued guidance that we'll go through later about the return to work and what employers should be doing to prepare for that and to make the employment space, the office space safe for people coming back. Number two, workers' comp still applies even if the employee is working from home. Be aware of that. Someone gets injured while working from home and they're doing work, potentially falls under workers' comp. The Centers for Disease Control, the CDC guidance, all has guidance covering what is a safe workplace, how to make it safe, as well as dealing with COVID in the workplace. Again, all three jurisdictions, DC, Maryland, and Virginia, have adopted the CDC guidance for the most part, as well as the OSHA guidance. Fair Labor Standard Act, wage and hour claims. We're already starting to see these coming in because it seems when people work virtually, they're never off the clock, even if the employer tells them they are. Employees must be paid for time they work even if it's after your work hours, if people are texting them or emailing them, asking them to continue to work, and we'll go over that. FFCRA, we've already gone over. The Family Medical Leave Act, federal, and the DC Act for you DC employers still applies, and be aware of it. And where that really comes to play, and I'm going to jump back up to one I skipped, is the ADA. The ADA is going to require you to consider reasonable accommodations and engaging in the deliberative process to see if there is a reasonable accommodation that can be given to an employee who doesn't want to come back to work. That can go hand in hand with FMLA leave, and we'll talk about that in a bit. And then finally, Title VII, anti-discrimination, anti-harassment. It all still applies during the during the COVID crisis, obviously. It also applies to the virtual workplace. So you can still have discrimination and harassment occurring in the virtual setting, and employers need to be aware of that. So with that list, let's turn to OSHA first. This is a general overview of OSHA. COVID is now considered a known danger, so employers have to provide a safe work environment. This is where we're starting to see the litigation jump with whistleblower claims. This is an article from August. 1,600 out of 4,100 OSHA whistleblower complaints dealt with COVID. And we're already starting to see litigation arising from it. This is the Amazon case up in New York. And what this litigation was addressed at, it was a novel theory to go after the employer, trying to keep it out of the OSHA regulatory and administrative law environment so they could have access to full damages. The argument in this case was failure to provide sufficient PPE and other requirements for the return to work was a public nuisance. So that's one of the new theories we've seen come up from the plaintiff's bar about how to bring OSHA claims or get OSHA claims brought in court outside of the OSHA regulatory process. Now, OSHA has also looked at the virtual environment, and here's the good news. While the home office is clearly under OSHA's compliance, they will not inspect the employee's home office if there's a complaint. Right now, they're not going to hold employers liable for home offices and don't expect employers to inspect them. Even with that, we're going to recommend you ask your employees to certify in some form that they have a safe workplace. They will also, if they receive a complaint, they're going to tell the employee that that's their policy, and they will not follow up any further with that. This could all change depending on how the virtual workplace goes forward, but this is good to know that you don't have to at all to inspect to make certain they have a safe workplace. Now, even as I said before, even though it's covered under OSHA, but they're not really going to do anything about it at this stage, it might be a good idea to ask your employees to certify that they have a safe workplace. And that's good for a couple reasons. Number one, you may have coworkers going to another coworker's home. We've had clients where the coworker has met with where the worker working from home has met with clients of the company at their home, and that can potentially expose the employer. So what would you want them to certify? That they're keeping a clean work area, that they have masks available, that they have the disinfectant cloths and liquid to utilize if they need it. It's not required under OSHA, but it's something we think all employers should think about, particularly, and this should be really thought about and looked at, if your employees are meeting with customers, clients, et cetera, in their home. Now, what does OSHA deal with or provide for about the return to work? Again, all of this has been adopted, essentially adopted, if not word for word adopted, by the 3 jurisdictions in their return to work guidance. Number one, and you're all probably familiar with this, is perform a hazard assessment. And what does that mean? It's in bullet 2. You go around your office before you reopen, you make certain you have hand hygiene stations properly located, cleaning and disinfection, equipment, wipes, etc., available for the employees. Social distancing, that means you put up your markers at 6 feet intervals, you put up your posters reminding people to stay apart. Identification and isolation of sick employees. OSHA essentially adopts what the CDC recommends. Workplace controls and flexibilities, what does that mean? It could mean barriers between desks. It could mean making the flow of traffic through your office go in one direction, so there's less opportunity for passing people multiple times. And then reminding people to stay apart if they're in the lunchrooms, so to speak, or gathering somewhere. That's the hazard assessment. Then they want you to have your policies in effect. If there is an illness or exposure, again, essentially adopting the CDC guidance. And then finally, workplace flexibilities. Both the CDC and OSHA are encouraging to continue telework or virtual work. And that's something all employers are doing. It's something you should consider to continue to do as the states reopen more and more. This hazard assessment, it's going to be very important, not only that you do it, but that you're able to show you did it. And what do I mean by that? If there is litigation down the road, be able to show that you did this in your offices before reopening. That will be a great help to you in litigation and could potentially prevent or give you defenses to certain claims. With that said, I would also recommend once you institute it and you put up the signs, the posters, the spacing, the protective barriers, etc., the hand cleaning stations, that you take pictures so you have it documented to show that these things do exist. Again, could be very useful to you down the road. Workers, we're going to move into workers' compensation. This will be real quick. It still applies. This is the federal workers' comp statute, but just know that Maryland, Virginia, and DC, workers' comp still applies. Someone gets injured at work, in the office, or at home, it must be reported and follow those guidelines. I'm really not going to say a whole lot more about that, but again, it hasn't gone away just because people are virtually working. Turning now to the CDC's guidance, I recommend everyone check the CDC guidance on at least a weekly basis about the return to work and their recommendations if there is a positive test. We're seeing these guidelines both out of CDC and OSHA. They change pretty regularly. There are updates or new guidance. It's very important to stay aware of that and try to stay on top of it. The one piece of the main guidance, if an employee, even if they're working virtually, if they test positive, they should let the employer know. And you all should be communicating that as part of your guidance to your employees, your return to work guidance, etc. That is something that is probably the most important thing an employer can do. And what does the CDC recommend in that regard? It's laid out right here. But again, I recommend you go to the website on a regular basis. So if an employee is working remotely and they report positive or being exposed to someone, you advise them to quarantine and seek medical assistance. Advise the employee of the sick leave policies, including the FFCRA if they haven't exhausted them. And you're going to want to limit contact with clients, coworkers, etc. during the period of quarantine and until and unless they're cleared to go back to work. The CDC guidance talks about a 10 to 14 day period and then a number of days being fever and symptom free after that as to when you can return to work. What I recommend is that you augment that and have them get a doctor's note indicating they are capable of coming back to work or can come back into the workplace. Until you have that, even if you're open partially, I'd recommend you have them continuing to work virtually, if at all possible. Now, if the employee does test positive and they want to keep working, you got to let them keep working. There's no prohibition against working while you have COVID or while you're going through the stages of it or recovering from it. Failure to allow them to continue working could be considered an ADA violation. So if you see problems with the employee's work or that they're not responding appropriately to requests for information, things like that, you may want to get involved and see if they want to take leave while they get over it. But if the general rule, if an employee wants to keep working even after exposure and they're working remotely, there's really no reason they shouldn't be permitted to do so. We're going to move on now, and we'll go through this relatively quickly. There are a couple key points in wage and hour. So keep in mind the federal Fair Labor Standard Act, as well as your state and local wage and hour laws, all are still in effect. We are expecting to see a lot of litigation with failure to pay overtime or improper docking of employees for time they may not have been considered working while they were working virtually. One of the best things to come out of the Department of Labor with this is their recent guidance about scheduling of work hours. The Department of Labor with this guidance is acknowledging that there are times when an employer may permit their employee to take breaks during the middle of the day for childcare issues. As a practical matter, what we see a lot are complaints from our clients that kids are learning at home and then suddenly around the lunch hour, all hell breaks loose with their employee who's working virtually. They may be on a Zoom call or something, and the kids are running around, the kids want to eat, etc. Something all employers should consider doing is being flexible. Give that employee that set time off so they can take care of those issues if they're going to continue working while the child is learning from home. But that time must be scheduled, and you want to document it so it's clear to everyone, the employee and other employees who may be asking them to do work, that during that period of time, no work is to be performed and they're not to be asked to do work during that break. If you have that in place, then you don't have to pay them for the time during that break. Once again, documentation is going to be critically important, and abiding by that documentation is going to be critically important. If you can't show that you did that and enforced it, then you're going to have a difficult time defending against a claim for overtime or just regular unpaid wages. Another field bulletin that came out from the Wage and Hour Division, again, acknowledging the COVID crisis and employers trying to shift to the virtual workplace. What they've now said, and there's a link here, if an employer provides a reasonable reporting procedure for non-scheduled time and compensates the employees for all reported hours of work, even hours not requested by the employee, if the employee fails to record that time or they work through a scheduled period and forget to put it in, the employer is not required to undergo impractical efforts to investigate or further report unreported hours. Where does this come into play? And let's take a law firm. Let's say the attorney is up late at night, happens to send an email to someone working on one of their cases, an hourly employee, and that employee responds and starts working. That employee forgets to bill that time or to seek payment for that time, and then 6 months later comes back and tries to make a claim. If you have documented that you have a reporting procedure and you've instructed all of your employees on it and trained them and they failed to put that time in, you're going to have a good defense against paying for that time. Now, I don't want you to think this is a get out of jail card, because as we all know, wage and hour claims are not fun. And there's the attorney's fee shifting provision that can make them very expensive. But at least under the Fair Labor Standard Act and the Wage and Hour Division of the Department of Labor, they're acknowledging there are going to be some practical issues with tracking time during the COVID pandemic. And this is potentially a defense for employers as long as you do it, document it, and be able to show that you did it. The next federal law we're going to turn to is the ADA that you need to be aware of under COVID. The ADA applies in its normal framework. Anyone with a disability is eligible for ADA protection. ADA protections apply at day one the employee starts working. There's no period. And it applies to employers with 15 or more employees. We also have to keep in mind the DC FMLA. Now, the interactive process and reasonable accommodation is particularly important to keep in the front of your mind during the COVID pandemic. And why is that? Because people who are vulnerable to COVID-19 could be considered disabled as a matter of medical disability or perceived or regarded as being disabled. We'll go into this much more a bit later, but think about someone who has comorbidities and they don't want to come into work, they want to keep teleworking, etc. That letting them continue to telework even when you're open at 50 or 75% or full is something that could trigger the ADA. So you need to be aware of that. And then once again, teleworking, virtual work, remote work, whatever you want to call it, would be in this day and age obviously considered a reasonable accommodation, absent there being a job that the employer has already acknowledged is not a telework or virtual work job. And we'll talk about that a bit more later. What other accommodations must you consider? Access to file and documents, access to adequate technology and resources. If an employee can't come to the office and the ADA has been triggered, you're going to have to consider these types of things as reasonable accommodations and what you as the employer can do to accommodate that employee. So what should you do as an employer with the ADA during the pandemic? Everyone should be reviewing their job descriptions to make sure they accurately reflect the essential function. Why is this important? If you're going to try to tell an employee a job is not a virtual work job and the job description is silent on it or says it is, you're really going to be in a bad spot trying to make that employee come back to the office. And remember, there's no magic words needed for an employee to put an employer on notice of a disability or the potential need for accommodation. So if an employee is asking to continue virtual work, even though you've called your employees back to the office, you must consider the interactive process if there is any potential that the ADA could be triggered. What does that mean? You have to consider requests for reasonable accommodations. Now, something also to keep in mind, accommodations related to family members are not under the ADA and don't trigger the ADA. Just because someone needs to care for someone who may be at home with a disability, that does not trigger the ADA, but it could trigger and will trigger the FMLA and the FFCRA. So just keep those in mind in your decision process. If a reasonable accommodation is denied, you really need to document it and the reason why it was denied and why it's an undue hardship. The only defense to denying a request for accommodation is that the employer can show it's an undue hardship. That traditionally has been a pretty high bar. I think we're going to see some changes with that. For example, you need people in the office, and that's why you can't accommodate every request for virtual work. If that's the case, have a good reason for why you need that employee in the office and make certain their job description indicates that the position is not a virtual work position or is subject to change. Just make certain you review your job descriptions because that's going to be very important if you're defending one of these claims. Now, what are some other issues that we're seeing arise? And I've touched on some of these briefly. Childcare issues. This is a real thing, as we all know. It is impacting, scores and scores of employees. And employers want to review their remote working, teleworking policies. Make certain that you have in there that this telework is not a substitute for childcare. And if it's any consolation, the federal government, when they allow teleworking, they make the same statements. that is not a substitute for childcare, and other arrangements may be made during working hours. Now, what's the reality? Telework has been a substitute for childcare since the schools have been closed down, and daycare has been also, particularly after the employee has exhausted their FFCRA leave. So what are some things an employer can do if you want to let the employees continue to work virtually? You want to be flexible. You got to get creative. And what are some creative ideas? There's many more, but these are just a couple. Consider a company-wide policy prohibiting calls or virtual meetings during specified periods of time. That could help your remote employee or your virtually working employee deal with childcare issues, say during lunchtime or at the end of the school day, while also not impacting your clients or customers. If you put something in place that says we're going to have a ban during these particular time periods, that could really assist your employees and could help make a difficult situation work much better so the employee can continue working. Again, under the FSLA and state and local wage and hour laws, if there are scheduled breaks, make sure it's documented and everyone knows. You don't want that rogue partner contacting the employee during a scheduled break and then getting upset because no one's responded. If you're giving the employee, excuse me, the time off and you're not going to pay for it, make sure everyone knows that. And then finally, the FFCRA, again, I expect there's probably going to be an extension of that. And depending on what schools do as they try to reopen and maybe shut down again, you're going to want to always consider the FFCRA as a part of your decision tree when trying to be creative with employees dealing with childcare issues from home. Some other issues we'll look at. Now, the daycare, considering the flexibility issues that you might want to consider when we get to the question and answer period, if anyone has done something that you think is working well, I would love to see that in the chat so we can discuss it and raise it if you don't mind sharing. One of the other issues that arisen, and I talked about this earlier, keep abreast of your state and local laws. Again, the DC Supplemental Emergency Act and Emergency Amendment Act extending DC FMLA protection and allowing the use of DC sick and safe leave for full payment of employees who are on FFCRA leave. Now, what should employers do? I think we skipped the slide. Let me back up. Nope. What should employers do as a best practices while employees are virtually working? Again, make certain you advise all employees that the EEO anti-discrimination, anti-harassment policies are still in full force and effect. Under the category, if you can't make things up, some of the recent cases we've gotten in about harassment or discrimination virtually makes it very clear to us that it is still a problem. And I would even say working virtually has lowered some barriers that people may have to things they say or may do or comments they may make that they wouldn't do in the office, but for some reason feel free to do so virtually. What can you do about this? Again, document, continue your training, do your training virtually, remind employees that this all still applies, and then remind your employees to report any complaints they have. If there is something that has not been reported and you hear about it, you should probably go out and investigate it so it doesn't blow up. Because what we've also found, things that happen virtually don't make it to HR quite as quickly as they do if it happens in the workplace. And then finally, with all of the new policies and that we have out there, like the FFCRA, like the DC Sick and Safe Leave Act amendment, virtually all of these policies are required to be posted. What can the employer do? Create a virtual HR hub where you have all your postings. So people know they can go to that hub, they can see the postings, and that way you're not only you in compliance with what the law requires, but you're in compliance with your virtual workforce as well as your in the office workforce, because they'll be made aware of it as well. With that said, I would include in that virtual hub references or links to your EEO policies, to your anti-discrimination, et cetera, and probably a link to your entire handbook if you don't already have it virtually. But it's something to consider, because I think a reality is, as employers and employees become more and more comfortable with remote work, we're going to see more and more of it going on. So having a virtual HR hub where all these things are posted, et cetera, is a great defense to an employer if there are claims brought later and that employee tries to claim they were unaware. Now, we talked about review job descriptions. I won't go over that again, but if there's the main point, if there's a job that you don't or is not eligible to be virtual, put it in the job description. Make sure it's known. Number two here, you got to continue your performance reviews, evaluations, and document performance problems. We are seeing a lot of terminations during the COVID pandemic. If you're going to let someone go, your requirement to document the reasons is no less important. It is still your best defense. If you're putting someone on a work improvement plan, get the documentation from the managers or supervisors who may be complaining about them and make certain you convey that information just like you would do if you're working in the office. Update your technology, making sure employees have the ability to work remotely. Another part of this is morale. Something we're seeing, and this isn't really governed by any law or guidance, but virtual events to keep kind of the esprit de corps going, to help employees communicate. You also don't want to lose employees during this time. And we're seeing a lot of employers with robust virtual platforms who engage their employees be very successful at retention. Again, open communications, make sure your employees know they can come to you at any time for any reason. Now I'm going to turn to return to work considerations. And I'm not going to go through a huge checklist on these because you all have probably already looked at these and have considered them. The links to the CDC pamphlet are here, that what they recommend and require for return to work. Those should be incorporated into your own policies and procedures. And remember, once again, all three jurisdictions have essentially adopted OSHA and CDC guidance for return to work. OSHA, again, the safe workplace, we talked about it earlier. Do your hazard assessment, clean workstations, PPE, et cetera. And one thing we didn't talk about, for your landlord also has obligations. If you see your landlord slacking off, allowing more people in the elevator than are permitted, or there's not appropriate distancing in the lobby area, point it out. Make sure you document that you pointed out if there's a problem. The biggest part of return to work is, if, just like virtual, if there is a positive or an exposure of one of your employees, follow the CDC guidelines. Again, click on them. We went over them earlier, but you always want to be looking at them to make certain you're up to date. Also look at your state and local. I think DC is the best example of this. That has the list of states that if you traveled to before you can go back into the workplace, you must quarantine for 14 days. That is going to become a bigger and bigger issue as offices start to reopen and deal with these issues. Number two, keep apprised of all the statutes, ADA, FRA, FFCRA, and FMLA. Now, if this is a new area I want to go over, I don't know if you all have been dealing with it, but we're starting to see it pop up where employees are refusing to come back into. Obviously, this is a very sensitive area. It's going to become more problematic potentially as offices reopen. So this section is going to be somewhat of a checklist of what you should consider if you have an employee who's refusing to come back. Two main points. Number one, it's not one size fits all. You should be talking to your employees to find out why. And the second point here is the why. Is it a generalized concern, not a specific health issue, just a generalized fear? Or is it something that might re-trigger another statute? So what's your decision tree? Number one, why don't they want to come back? Ask them. Number two, do they have FFCRA leave or FMLA leave available that they could use? Third, depending on what the employee tells you, is it an ADA event? And we're going to get into this a little more deeply in the next few minutes, but the EEOC has given guidance that adopts what the CDC says are people and conditions with people with the conditions that could be at risk. And under the most recent EEOC guidance, they have indicated that this could be, or these categories could be considered disabilities under the ADA. And what does that mean? If they're saying it's potentially under the ADA, that means you have to consider reasonable accommodation if that employee is refusing to return to the office. So keep that in mind anytime an employee refuses to come back, and always keep in mind if you have furloughed employees, when they're coming back to the office, or as you reopen, they too are still eligible for FFCRA, ADA, and potentially FMLA leave for whatever their reason might be that they don't want to come back to work. Now, has the employee, next part of your decision tree, have they been working remotely, and is it working? Can you continue the remote work? And if you can, it's something you consider. If the employee has not previously used FFCRA, that is available to them to use until they exhaust it. Even if it's a generalized fear, but they're saying, I think I'm having symptoms, I'm concerned, etc., that could trigger FFCRA leave if they haven't already used it up. Refusal to give that leave could be considered retaliation, so there's no reason to be stingy with it. If you think it's a triggering event, use it for that employee who's protesting coming back. Now, what I talked about earlier are the guidelines adopted by the CDC and their guidance that now the EEOC has said could potentially trigger ADA protection. One of the elements of the EEOC guidance is it just says older adults. Normally, age is not a protected status under the ADA, only a disability is. But because the CDC guidance has thrown this in, you have to consider it, and probably should consider it, as you're working with those employees who may be protesting about coming back to the office. Arguably, if an older adult does not have another issue that would be considered a disability, the ADA should not apply, but now the EEOC has made it a little murky. And we also want to be cognizant of older workers. When you look at the age categories put out by the CDC, workers 65 and above can be at greater risk. So again, always look at that guidance as well. These are the list of people who the CD considers are at increased risk. I would say that all of these conditions are considered disabilities. The second, so they would be protected under the ADA, and you would go into your interactive process and have to consider reasonable accommodations that you could implement so they could continue working virtually, or if they did want to return to the office, what accommodations you might have to give them in the office to continue working virtually. The next category, the CDC put out as, quote, might be considered an increased risk for severe illness. Now, once again, almost all of these are considered disabilities, except we've highlighted smoking. Now, someone who's just a smoker that doesn't have COPD or some underlying health issue normally would not be considered as someone with a disability protected by the ADA. However, with the EEOC recent guidance that they're looking at the CDC guidance for what could be considered a disability, you should go through the interactive process with that employee to determine if they have any other issues that rise to the level of a disability. If they don't, you may not have to give them accommodation just because they're a smoker. If they do have another condition that rises to the level of a disability, then you would. I will admit the EEOC guidance is confusing, particularly for smoking and age, because they're not usually considered medical conditions or disabilities in and of themselves. Also, the EEOC over the years has issued a lot of guidance that they thought was correct that the courts have stricken down. Where this will go, we don't know, but your safest probably course, if somebody raises a question about returning to the workplace or concerns about it, always remember the ADA, and if you think there is something, a triggering event, go through the interactive process with them. It doesn't mean you have to agree with them. It doesn't mean you have to accommodate them, but go through the process before you make that decision. Now, this leaves us the last category of employees, those who don't want to come back to work because they have just a generalized concern. They don't have a protection under the ADA. They don't have a protection under the FFCRA or FMLA anymore. It's just a generalized fear. What should your decision tree about deciding whether or not to require them to come back? Number one, could there be a claim of retaliation under OSHA? In other words, is that employee complaining that they don't think you have proper PPE or other safeguards in place? If that's the case, demonstrate to that employee that you have it in place and document that you demonstrated it. If you've given them their FFCRA and FMLA leave, there should not be an issue about that or a retaliation claim there. Number two, always keep in mind discrimination issues. Is there an argument that the employee could point to, well, you let this protected class of people not come back to work while you're denying it to me? And something that comes to mind, an employer may allow individuals with children to stay out longer before requiring them to come back to work. In DC, family status is a protected status. So if someone can point to that and say, but you're not letting my group come back to work, and or you're making us, and they are a protected group as well, could trigger a discrimination claim. So just keep that in mind and look at it. Next point, is it really necessary for the employee to come back to work? If it's necessary, should be in their job description, and you should be able to prove that it is necessary and you need that employee back to work. Oops, sorry. Finally, if there are issues about return to work, you also have to consider those issues if the employee is required to go to a client's workplace or they have to go somewhere. Keep in mind when you're asking that employee to travel somewhere to do your work or to go to an employee client's workplace, that you should be going through these same checklists if that employee is pushing back and saying, I'm not comfortable doing that. Because remember, requiring them to go somewhere else to complete work for you triggers all of these statutes: ADA, FFCRA, FMLA, etc., and wage and hours. So keep that in mind if you have employees that you require to work at other sites. And then finally, this is a good article from Law 360. It's worth reading. I'll just briefly summarize it. Look at your past opposition to teleworking or virtually working. Is it legitimate anymore? Should you consider more broadly expanding telework, not only during this crisis and beyond? Record your company or your firm's experiences with telework, virtual work. Were they good or were they bad? If you don't want to allow it or you want to cut back on it, have a reason and be able to document why it didn't work or didn't work for a category of employees that you don't want to allow it to or you want to cut it back from. Don't bank on the undue hardship defense. Again, a very, very hard one to win. If in-person attendance is essential, be able to approve it. We already talked about one size doesn't fit all. You want to have an open line of communication about these issues. And finally, don't assume that telework is the only solution. There may be other solutions within your offices that you should consider. And what do I mean by that? If you have a group of people who don't have to come in and aren't coming in, make their workspaces available for employees who have a hesitation or are concerned about coming in so they can work in an area that is more private, may have a door, et cetera, et cetera. I am at the end of the presentation. I know we covered a lot of information. If there are any questions you all have, we finished a little early, but I'm happy to look at those in the chat room if you want to type them in and try to respond. Okay, right now I'm not seeing any coming in. I am also available. All of our contact information you all should have it, but it's also in the PowerPoint. I can be reached via email or call my office line if you have specific questions. We're happy to make the deck available as well. So unless I see any questions coming into the chat, that'll be the end of the presentation. And hopefully I get to do this to the ALA in person next time and see people and have questions during the presentation, which I always prefer. I hope everyone stays safe and happy and healthy, and look forward to seeing you soon.